I'll call the case of Jennifer Mendoza versus Liana LeBaron. Ms. Mendoza is self-represented. Ms. LeBaron is represented by attorney Corey Briggs. Let's have a brief background on the procedural history of this case as I understand it, and then I can turn to both sides and you can each let me know whether there's any inconsistencies between my understandings of this case and yours. So there was a filing that was made by Ms. Mendoza in the, I believe, the early spring of 2023. There was an ex parte minute order that was reflecting that Ms. Mendoza was asking to continue the hearing from March 6th to April 3rd of last year due to some unavailability on the part of Ms. Mendoza. That was granted by Judge Lynch. Then on April 3rd, the parties appeared in court. My understanding is that this was the first appearance by Ms. LeBaron and her counsel, Mr. Briggs, and the court set an anti-Slapp motion to take place on the same day as a long cause hearing and scheduled both for May 8th of 2023. A modification to the terms of the temporary restraining order was also put in place at that time. The parties reconvened in front of Judge Lynch's third court appearance on the case on that date of May 8th, and the court granted Mr. Briggs' anti-Slapp motion in part. There was some subsequent documentation from a minute order earlier this year which indicates that it was granted 20% is what I read, and in so doing then struck those certain allegations which he found to run contrary to the anti-Slapp statute, and then there was a hearing that proceeded. Witnesses were called. Ms. Mendoza was still represented by counsel up until this point, and then ultimately at the conclusion, it was Gil Cabrera, if I understand correctly. And then ultimately at the conclusion of that hearing, there was a decision made by Judge Lynch to keep the terms of the modified TRO in place for roughly a 3-month period of time until the date of August 14th of 2024. It's my understanding from looking at the minute orders that reflect the outcome of that May 8th hearing date that it was anticipated that should there be no further violations that the TRO would be permitted to lapse on that August 14th date. The parties then reconvened on that August 14th date in front of Judge Lynch, and there was an inquiry as to whether there were any further allegations, and I believe it can be inferred that Ms. Mendoza responded in the negative, that there had not been, and as a result, Judge Lynch decided that the TRO was to lapse at that time. It was dissolved. Mr. Briggs filed a motion for attorney's fees and costs, and that was heard by Judge Lynch on January 2nd of this year. Both parties appeared for that court date, and ultimately, due to Judge Lynch making the determination that 20% of the anti-Slapp motion had been successful, ordered attorney's fees and costs in the amount of $32,683.29. There was a brief ex parte that was filed. I believe a colleague of Mr. Briggs by the name of Nora Passin, P-A-S-I-N, made an appearance and requested today's date. And I was the judge for that court appearance, and I granted the request to put this on calendar for today. So for today, we have this request. Before we go further, would either side like to be heard on my summary of the procedural history of this case? Mr. Briggs? No. Ms. Mendoza?
No, you did very well. Thank you.
Okay. So for today, we have a request that has been filed by Mr. Briggs pursuant to California Code of Civil Procedure Section 685.040. It is a request for attorney's fees And that code section reads as follows. The judgment creditor is entitled to the reasonable and necessary costs of enforcing a judgment. Attorney's fees incurred in enforcing a judgment are not included in costs collectible under this title unless otherwise provided by law. Attorney's fees incurred in enforcing a judgment are included as costs collectible under this title if the underlying judgment includes an award of attorney's fees to the judgment creditor pursuant to subparagraph A of paragraph 10 of subdivision A of section 1033.5.
Your Honor, can I be rude and interrupt you for a second?
Go ahead.
I thought we were here for an ORAP. I was served with a motion to tax on the post-judgment cost memo just a couple of days ago and was told that it was going to be on July 22. So I actually didn't even know why you were going through all the motions until you started to make it sound like you're going to rule on a motion to tax.
So this is not before the court today?
No.
That
it's
was my
scheduled for
impression.
July 22. We will oppose it. The motion was filed late, so like a cost memo in a normal civil case, the court doesn't have jurisdiction even to rule on it, but we'll brief it when we get there. Today is nothing more than an ORAP, and we need the witness or the judgment debtor sworn in so that she can answer some questions. She did serve me when I got here this morning with 15 plus pages of objections to the document request that was served on her. If you are available to entertain my response on the objections, that would facilitate things, but in light of the objections, I suspect Ms. Mendoza brought me no documents, which means we're gonna have to continue today anyways. So I'd like to just jump to the objections, and then maybe we can do all of this on the 22nd, the ORAP and your motion to tax ruling.
I see.
That's just my suggestion. I'm open to others, but trying to minimize trips here and impositions on you.
Yeah, I had a misunderstanding apparently on what was before the court today. I believed that today was the 685.040 attorneys fees and costs motion. Okay, Ms. Mendoza, over to you.
Yeah, I was under the same impression. So I received I'm just trying to think what I was, the notice to appear today was the memorandum of costs. No, it was for the a judgment debtor examination. That's why I'm here today.
In your ROA, Your Honor, it was filed May 17, 2024.
Yes, I see that now.
Yeah, and then I filed, well, I filled out the claim of exemption and financial statement, and I'm not allowed, it said I could, the clerk would not let me file it, so I lodged it with the court on Monday, and I emailed a copy to Mr. Briggs, and I mailed him a copy of
Okay.
and then I also I filed the motion to strike or tax his costs, and the court set, or the clerk set a hearing for July 22nd for that. So
Okay.
Do you not have the claim of exemption?
I have the claim of exemption here. It's just been handed to me.
Okay. And then what I handed Mr. Briggs today is objections to his document requests, but also I'm just objecting to the time period. He wants to go back 4 years, so I'm objecting to the time period, and but I'm not. For most of them I did respond that I'm willing to produce, but I don't think I should have to carry boxes of documents into the courtroom today and just turn them over. What I responded is that I think we should, mutually agree on a date, a time, and a place where I will meet with Mr. Briggs and bring him the documents that he's requested. He can decide what he wants copies of, and he can either make the, I'm gonna retain my originals. He can have a copy machine there and make the copies, or I can have the copies made and he can pay for them. However, I'm not saying I'm not gonna produce any of the documents. I understand that. But I was not asked, the court did not ask me to bring documents here today. And then I also wanted to, one thing that hasn't been made clear is I have made an offer to make payments. And of course, the offer I made, and I brought that with me, the letter and emails between Mr. Briggs and myself. And of course, I was anticipating that we would agree on a payment plan or, whatever he wanted. But he has said, he's not, well, also the thing that's unclear to me is the judgment says I owe Leanna LeBaron. It doesn't say I owe Corey Briggs. So that's one thing I wanna make clear. I'm willing to make payments on this, whatever, you find is, equitable and fair. And, but I need to know if I pay, Judge Lynch told me to pay her, but if she agrees that I should pay Mr. Briggs, is that okay? I'll do that if that's what I'm supposed to do. And then I have sent checks, they have not been cashed. I sent a check to Ms. LeBaron, and then I sent a check to Mr. Briggs, which Mr. Briggs emailed me and said he's refusing the check and he's going to destroy it. He won't, because he says he won't, he said, a check is not a lawful offer of money, my personal check. But he has no reason not to believe that my check isn't good. He gave me a case that's 50 years old and nothing like this situation. He has no reason to believe that my check is not gonna clear. He wants me to give him cash or a cashier's check, but I think ultimately he just wants me to pay him the whole entire amount. But I think that's gonna be up to the court to decide after I've filed a claim of exemption, whether, and the financial statement, whether I can afford somehow to give him the whole amount of money, which I'm saying I can't. But I am willing to make reasonable payments that I can't afford. So that's why I'm here today.
I see. Okay.
Is to figure out, can I still pay him? Should I still pay him? I haven't really gotten a counter offer from them, except that they're not gonna accept my checks.
Okay. Very well. So if I understand correctly, there's a request by Mr. Briggs to set this for July 22nd. And do I have that right, Mr. Briggs?
You're right that I'd like to do them all at once. If we could do a different date, I'm supposed to be in start a trial that day in San Bernardino. I'd like to pick a different date, but apart from that, if we could just do it all at once, it'd just save everybody time and effort.
Okay. And so in light of that being their position, Ms. Mendoza, would you have any issue with our continuing this request that you have so that it can be heard on the same day as we would otherwise be hearing Mr. Briggs' 685.040 request for costs? Any issues with that?
No.
We could do it earlier in time. I think I would be somewhat reticent to do it today, but we could do it earlier in time if you want to set it for two separate dates, and we could try to have those two dates be roughly close together.
No, the one day is fine. But I'm just, I'm not sure how I should proceed.
Well, did you contemplate possibly getting an attorney?
I can't afford that. I've already had to pay an attorney.
Okay.
And now, I'm not disputing that I'm not gonna pay Mr. Briggs. It's just, how, how are we gonna make that happen? And it's gonna have to be monthly payments.
All right.
But it has to be something I can afford.
Understood. And Mr. Briggs, is there a desire to meet and confer with Ms. Mendoza, or no?
Oh, we've emailed extensively.
Okay, so it's an intractable impasse.
No. What she wants to do is write a personal check for $25 a month,
Mhm.
which doesn't even cover the interest. What I've told her, including legal citations, is it cash or cashier's check, because that's what's required for satisfaction of the judgment. And the check should be made payable to Briggs Law Corp trust account. They're not payable to me. My client wants me to be doing the collecting, because I'm the one who has to do the accounting for all of this stuff, and it's for attorney's fees.
Mhm.
So there's no effort for this to line Corey Briggs's pockets. We go to my trust account. She told me she would pay by cashier's check, and then she sends me a personal check, which, by the way, I have the last one here. I was gonna give it to her today. But I'm happy to chat with her, but we have to get back into the atmosphere, not the stratosphere. We think $25 is gonna cut it. So, but that's not why we're here. I'm happy to talk more, but I don't wanna waste your time on things that aren't before you today either. I think you said we could do an earlier date. July 15 is clear on my calendar.
Well, I'm not sure. I have to check in with the clerk.
I was
but
gonna
let's-
ask if it worked for you.
Let's
I'm
take a
just
look.
Throwing it out.
So I would think that what we would want to do in this case, just to be on the safe side, is 2 afternoon settings, each of which would be relatively close together in time.
We have a long cause set in the afternoon of the 15th. We don't have a long cause available clear afternoon until August 5th.
And then do we also have the 7th?
Yes, Your Honor.
How about the afternoons of August 5th and 7th, and then the 7th would be just a fallback in case we don't complete our work?
I'm with Judge Coyote in a bench trial on the 5th, but the 7th is clear. Can we just do everything on the 7th?
Well, I would hope so. Ms. Mendoza?
Yeah, I'm having two foreign exchange students are staying with me for several weeks this summer, and the 7th is the day that I have to take them to Los Angeles to catch their plane.
How about the 12th, Monday the 12th? Would that work?
That's fine.
No. How about the 14th?
How about the 14th, Ms. Mendoza?
Yes, that would work.
Okay, and then how about the 19th as well, as a fallback in case we don't finish on the 14th?
Yes,
So the 14th and the 19th, Mr. Briggs?
On the 19th, I'd have to be done by 2 p.m. I have to be in LA at 6 p.m. and you know what traffic's gonna be like between here and there.
How about the 21st instead? That's the following Wednesday.
Can make it work.
Ms. Mendoza?
yeah, I can shoot that.
Okay.
So that's the afternoon.
At 1:30 p.m., yes, that way you'll be the only case that I have on my calendar, and I'll be able to give you a full 3 hours. So it'll be the afternoon of Wednesday, August 14th, 1:30 p.m. here in Department 21, and the same time and location 1 week later on August 21st.
Are we all waiving notice? I don't wanna have to reserve on the ORAP or anything like that.
Ms. Mendoza?
Yes,
Yes.
And will you also entertain a ruling on the objections to the document production at that time?
Yes.
Okay,
That will be addressed, I believe, at the outset of the hearing.
okay.
so I do not need to produce any documents before August 14, or should I produce documents?
Let me check in with Mr. Briggs and get his perspective on that.
My perspective is that since we're enforcing a judgment that includes recovery of fees and costs, this is all on Ms. Mendoza's tab. So anything she can do to minimize the time I spend getting what we're ultimately gonna get as part of a legitimate judgment debtor exam is in her interests. If she wants to give me nothing and you overrule all of the objections and she has to turn something over and we come back again, that's on her. But my preference is that she give me things that aren't in dispute at a minimum. I'd also point out that she chose a 6-month cutoff for the documents. She lost the case on the anti-SLAPP in May of last year, over a year ago. There may be some movement of assets, which is why she's artificially chosen the 6 months. So I would think it would be responsible for her to choose at least 2 years to cover the period before she filed this lawsuit. And if it ends up being longer, we'll take that up on the 14th. But that would be my recommendation if she were paying me to help her get out of something for the least amount of money.
Ms. Mendoza, do you understand that?
Yeah, I could do 2 years. My biggest concern is that he propounded 40 separate document requests to me, and for a 4-year period, and that's very onerous. So I could, 2 years is better than 4 years.
Okay, so let me just, for my own peace of mind, let's make a list of everything that's anticipated to be before the court when we reconvene on the 14th. So we will be having the judgment debtor exam.
Correct?
We will be having the subsequent request for attorney's fees being filed by Mr. Briggs, and that's,
Technically, Your Honor, it's her motion to tax the costs and fees claimed in the post-judgment cost memorandum.
and that's per CCP section 685.040, right?
I don't recall the PIN, but it's a 685 neighborhood, yes.
Okay. And that is really for your client to be able to recoup the costs that she's incurred in order to collect on a judgment?
Yes, sir.
Yeah, that's the code section. And I do believe that's the code section that you also cited too.
I don't have it committed to memory on the PIN.
Very well. So those two things will be before the court. There's also going to be a motion to strike, is that right? Ms. Mendoza, did I understand you correctly?
It's the same motion, to tax and or strike,
Okay.
or to strike and or tax.
All right. I think it's also likely that there will be an additional media request. So now that you understand that in advance, and you also understand that we will, in all likelihood, be discussing much of your personal financial information, should I also anticipate that you'll be filing a motion to narrow in some way the media coverage, or no?
No.
Very well. Is there anything else that's anticipated to be before the court on the 14th of August? Okay, so it'll be your motion to tax and strike, Ms. Mendoza, and then we'll have essentially an evidentiary hearing on the judgment debtor exam, and then we'll move on to the motion to tax, the CCP section 685.040, the request by Ms. LeBaron to recoup.
Does Your Honor do the JDXs here in the courtroom, or do you send us out to a conference room?
We can do them in the courtroom.
I want to know whether I should schedule a court reporter and where I tell him or her to come for that, or I can end up just recording it on my phone. But I didn't know where we would do it, and I want to make sure I'm set up appropriately.
I believe that it would be best if we did it here with a court reporter, if that's something that you are going to be paying for.
Yeah, right.
Okay. And anything further?
No,
Do we need filing deadlines to be set?
we'll do it per code.
Okay, very well. All right, in that case, and I have your lodgement here, Ms. Mendoza, your claim of exemption. We'll just hold on to this,
Okay.
and we'll have that available for us on August 14th. And have a good rest of your day.
And everybody's waived notice, is that correct?
Yes,
We're
we addressed
waiving
that
notice.
previously.
Okay, thanks, Your Honor.
Yep,
Thank you.
have a good day.